pleasant evening where our Honorable Chief Justice A.P. Sahi has consented to give a lecture on the topic. May I now invite our President of the Madras Bar Association, Mr. A.R.L. Sundaresan, Senior Advocate, to welcome the audience and introduce our speaker. Sundaresan, sir.
Good evening, my lords. The Honorable Chief Justice. The Honorable Chief Justice does not require any introduction to our bar, nor to anyone in the whole country. Welcome to all the members of the Madras Bar Association and all the audience who are live watching this lecture. At the outset, I thank my Lord the Honorable Chief Justice for having consented and given us time for this lecture on a very important topic chosen by His Lordship. We had sent a few topics to the Honorable Chief. Chief was kind enough to choose the topic Basic Structure Doctrine. The most important one so far as remedies and the rights and duties of the citizens are concerned. We welcome the Honorable Chief Justice, and I am sure with the rich experience of the Honorable Chief as a lawyer in the bar and as a judge in various courts and as the Chief Justice of the Madras High Court, he would give a lecture which will be very useful for not only the youngsters but also the seasoned lawyers, and we will know many things which we still need to know on the basic structure doctrine. Thank you, my lords, and I request you to kindly give us this lecture. Thank you.
Thank you very much, Mr. Sundaresan, and I greet all of you who are there on this webinar. This opportunity that was given to me by Mr. Sundaresan and the Madras Bar Association was something which was long in the waiting. And with this almost 3 months of lockdown, I hardly had any interaction. And therefore, this was a very good opportunity to meet all of you face to face, and then to at least do something what we are supposed to do, and that is talk law. Mr. Sundaresan had suggested 3-4 topics, out of which one was tribunalization. That was also one of the topics which could have been picked up by me. The topic of basic structure doctrine was chosen by me because there is one thing which always has been troubling me about basic structure doctrine. Namely, it tells us what cannot be changed. It is an injunction on the Parliament. The Parliament comprises of members represent the people of this country. The question which troubles me is, can the people of this country be injuncted from even changing what is known as the basic structure of the Constitution? Namely, constitutional supremacy, as we know, separation of powers, the power of judicial, and the host of other features, including the fundamental rights chapter, the chapter around directive principles of state policy, the question of unity and integrity of the nation, and of course the secular socialist democratic republic doctrine, which is also ingrained therein. To be more precise, I would begin by saying, and which I have been advocating all through in all my interactions, that it is change which is permanent. And it is the old theory propounded by Heraclitus that nothing is permanent except change. So what is this unalterable material or unalterable feature which has come up to be discussed in the basic structure doctrine and the purpose of doing so? This is vis-a-vis the mindset of the Constitution framers who thought it proper to engraft within the Constitution such fundamental and foundational principles so that the nation remains united. It was with great aspirations that this nation came into being. And therefore the Constituent framers had everything in mind to secure everything for generations to come and lay down principles. What I would now connect with the natural law theory of all human beings, which you can say, the idea of every human being preserve himself from the individualistic point of view. The preservation of the nation that came into existence or was about to come into existence was there in the mindset of those freedom fighters who later on formed that group of Constituent Assembly and then took up this onerous task, this rather Herculean task of framing longest written constitution in the history of this world. We all know it's not necessary to quote everything, but nonetheless reflections are necessary. For example, Professor Ivor Jennings, he was a bit skeptical about the success of this lengthy constitution. But fortunately what happened was that the very same Professor Ivor Jennings was entrusted the task of framing the constitution of a neighboring country, namely Ceylon, which gained independence much later than our country. And the constitution which came to be framed and written, of which Professor Ivor Jennings was also one of the mooters, failed in 7 years and it had to be changed. So the criticism of Professor Ivor Jennings, or for that matter any other criticism, has not been able to dent much except the Parliament itself. And the reason is our Parliament, either necessary or unnecessary, brought about not less than 120 amendments in the past almost 75 years, and therefore proved this theory that the Constitution does require a review, a constant review, and that is why it is a living organism. This is how it was described. But coming back to the basic structure doctrine, the basic structure doctrine is, as I said earlier, is an injunction. And why was this basic structure doctrine evolved by none else than the apex court through its pronouncements, as there is no such definition contained in the Constitution. The pronouncement came necessary out of many necessary events, savory and unsavory, that trace our political history, which we all know. But why was it necessary to pronounce on it and to explain it? I must tell you that the Constitution, being the mother of all laws, has a profound existence because it is this document which instills faith and confidence by describing the aspirations of our freedom fighters and of our generations to come as to how we have chosen to govern ourselves. Governance requires certain amount of faith in something which forms the pillar of such governance, and which, of course, our country is the Constitution of India. It is here I would like to connect it with natural law and with the rights of an individual, the aspirations of an individual. The individual wants and he aspires for to live in a society which is organized and which is not uncertain. It wants certainty in life, which we call security in life. But in order to achieve this, what was that natural law theory which we can connect with this basic human instinct? Basic human instinct, as I said earlier, is to preserve itself, conserve itself. And this instinct of preservation and conservation always has something else to impel a human being, think. And that thought process begins with some sort of suspicion or doubt that may arise in the mind of any individual or a collection of individuals. When we form into a society, human beings have the natural capacity, rather the cognitive capacity to reason out. And in order to reason out, they have to doubt. They have to suspect at times not only their environment but their own human behavior itself. And this is directly connected with the sense of security or preservation that one has in mind. It is this basic human instinct which impelled all these theories that has evolved into create something permanent in order to ensure that at least this will not change or will not allow anybody to change what is fundamental to life. These fundamental principles includes one very basic concept in the field of governance when it comes to social life. And that is, and many of us will agree, that after having achieved what we call freedom, which is the pursuit of happiness as described in the American Constitution, is to avoid conflict. And conflict between the individual on the one hand, who cherishes liberty, and the might of that organism which governs that individual. The organization which governs you is also made up of individuals. May it be through elections, franchise, nominations. We will not enter into that at this stage. but it does involve the thought process as to how you are to be governed. And what people detest is any sense of insecurity, for which one of the modern thoughts that emerged and of which Montesquieu is the proponent is to avoid the rule of tyranny. It is this basic human instinct which impels you, or any individual for that matter, that your liberty should not be compromised by any tyrannical rule. Now here lies the seed of the doctrine of separation of powers that we have in our Constitution. And that was propounded long ago, as you very well know, by Montesquieu, and has been followed and adopted in various democracies. This fear in the mind of an individual is the connection to the theory of natural law, where right and wrong used to be the method of search by those political, social, and jurisprudential scientists who advocated the theory of natural law. It has traveled down and trickled down a lot, right from the olden days up till modern era, even now, Dworkin, and so many other scientists which I would not like to refer to. But the basic principle is that this human instinct of fear of tyranny, brings about that basic principle, one of those basic principles which forms the foundation of the basic structure doctrine that came to be engraved in the Constitution and explained by the various pronouncements of the apex court paragraph. Here, what I want to say is, sorry, that word paragraph occurred because as if I was dictating something. Please excuse me for that. The point that I am trying to make is that when this approach started being discussed by the Supreme Court and by various other persons throughout the country about the theory of separation of powers, the question of amending the Constitution and the exercise of constituent power by the Parliament came to the forefront. And you all know Article 368 of the Constitution of India. It has very two important features. One is that it begins with a non-obstante clause, notwithstanding anything contained in the Constitution. And the second is any law. Any word, any occurring, and the word notwithstanding, both are reflective of this, that they clearly mandate the supremacy of the Parliament in proceeding to amend any part of the Constitution. The Parliament therefore is empowered to do so. But this basic instinct of tyranny, where one wing of governance tries to trench upon liberties of the citizens, has to be checked. And this check and balance, through the separation of powers, finds place in judicial pronouncements in our country. The judicial pronouncements begin right from the minority view of Justice Subbarao in Sajjan Singh versus State of Rajasthan. But even there also Justice Mudholkar in one of the decisions had indicated about the basic features of the Constitution. Justice Mudholkar had indicated it in a different context when he was discussing the judgment of the Pakistan Supreme Court that was delivered in 1961 in relation to the change of the constitutional powers that was brought about way back in 1956. These discussions were going on, but insofar as we are concerned, it came to be crystallized in the famous case of Keshwanand Bharti, which had its precursor in Golaknath's case. Justice Subbarao was one of the judges who were in minority in Sajjan Singh versus State of Rajasthan. And when Justice Subbarao came to head the 11 judges bench after his own reference, in Golaknath case, a 6-5 majority decision came into existence, the correctness whereof came to be doubted by the 13 judges bench of the largest benches and the longest heard cases in the constitutional history of India. But the foundation of this basic structure doctrine, together with its natural law theory, had its genesis in a document which historically is very interesting to know and has been mentioned by many eminent jurists. It was a lecture given by Professor Konrad Dietrich, a German professor who had come in 1965 to the Banaras Hindu University to deliver a lecture. Dr. Dietrich had been a propounder of this theory, and for that I will request you to kindly go back in history prior to the Second World War, when in Germany there was the Weimar Constitution. This constitution in Germany had certain enunciations, and one of them was injuncting the power of the parliament from amending certain essential things. But the power of amendment was there also. That amending power was misused by the rise of the Nazi party, and Adolf Hitler made it a weapon to alter the entire constitution. And that is part of history which need not be repeated. This rule of tyranny was brought about by the misuse of that power. And then the Second World War followed. After the Second World War, when the Federal Republic of Germany was formed, it is there that in the German Constitution, the Constitution framers came up with what is known as the, now here the words are to be marked with, eternity clause. Meaning thereby that there are certain eternal elements of governance which should not be allowed to be altered. Professor Konrad Dietrich referred to these elements and delivered his lecture in the year 1965. We all know, as a matter of history, and it is really relishing to note of it, take note of it, that the said lecture was requested by Mr. M.K. Nambiar to be cited in the Supreme Court. And the same line by Mr. M.K. Nambiar when the Goloknath case was being argued. And the same line was adopted by Mr. Palkiwala, where his primary and primordial argument on the basic structure doctrine rested on this very document, which was again produced before the Supreme Court in Keswanand Bharti case. This is a short historical introduction to the theory of the basic structure doctrine that came to be ingrained in the decision of Keswanand Bharti, which still holds the field today and has been expanded and explained thereafter in Minerva Mills and other cases which all of you are aware of and need not be repeated. The point that I am trying to make out is that the apex court has pronounced that these are the inalienable features and unalterable basic structures of the Constitution that cannot be abrogated or repealed or done away with. It is in the nature of an enunciation of a theory which acts even today like a permanent injunction against the Parliament and a warning not to attempt any such legislation or any such amendment in the Constitution that may hit the basic structure doctrine. The said basic structure doctrine, therefore, as others have also said it and I also find, came to be enunciated by the Supreme Court through judicial pronouncements. But the question is, can these permanent injunctions be ever vacated, should be vacated, or whether these injunctions have the eternal value to everlast and outlive the Constitution itself? The question is, who will do it? So long as the law in Keswanand Bharti case stands, the Parliament obviously cannot alter the basic structure of the Constitution that has been broadly defined. It also cannot make laws that can extend beyond the barriers of the basic structure doctrine. But nonetheless, as I began by saying, nothing is permanent except change. Then why should there be a permanent injunction? It is here that the answer can be searched for, through traversing as to in whom the sovereignty lies. If we advance the theory of constitutional supremacy, then the Parliament cannot travel beyond the authority conferred on it and as interpreted by the apex court. If we go by the theory of constituent power of the Parliament, can there be another attempt to change any of the basic structures of the Constitution? And if the sovereignty lies, as the preamble says, we the people of India, in the will of the people, then whether this expression of the will through the Parliament can still be exercised or as Professor Upendra Bakshi had once said about a referendum being called. The question is, can this be changed? There is one thought-provoking quote which I would like to share with you, and that is by Chief Justice Warren Burger of the United States, who was being interviewed in the year 1986 by a television channel. The question put to him was, basically, can you change or can you review in the context of the US Congress? Can the US Congress change it? But when he pondered over it, he said, but when we decide, that is the judicial, but when we decide a constitutional issue, right or wrong, that's it until we change it. Meaning thereby, as it happened in our case, till Keshwanand's Bharti's case, or if it changes in future by a larger bench. But he goes to the second alternative, which is the issue that I have tried to discuss today about change and by whom. He says, all the people changed it. He recognizes the sovereignty of the people. And he then emphasizes, don't forget that. The people made it and the people can change it. The people could abolish the Supreme Court entirely. Now this was a revolutionary statement, and it certainly requires a revolution, either to overthrow the Constitution or change it or abrogate any part of it. But is that possible? Or should it be done? And if so, should such a right be recognized? It is here where I would like to share with you that theoretically, if the people have given unto themselves the Constitution, then the people can decide and choose their form of governance. And for that, the expression of the will of the people through the Parliament, not only with regard to form of governance, but with regard to the entire system of governance, can be reviewed. But in what manner? And when will that situation arise? On the practical side, while analyzing this ideal state, at present and in contemporary times, looking to the political history of this country and viewing it in future, so long as our democracy survives and so long as the right of franchise is there, the diversity of our country and the nature of response of our electorate in the recent quarter century gives a picture as if there cannot be another period like the freedom movement that we had for the time being. The reason is that the level of respect, the level of tolerance of an individual with each other, and the level of human relations has certainly seen a revolution. I would not say that there is decadence, but certainly people have started asserting themselves more vigorously. And therefore, this does not bring about a substantial reform or a universal sort of comprehensive spirit that the people of India would rise in one voice to say that let us abrogate or allow the Parliament to abrogate some of these basic features of the Constitution. This vision on the practical and pragmatic side does not appear to be available in the near future, and which in my opinion is better for the country, for its stability and for its good governance. The reason is that this fundamental document of governance which we have has certain very core human and eternal values. I am using the word eternal because of reference to the eternity clause in the German Constitution. Here also, these appear to be unalterable, and therefore our Supreme Court, very rightly, even though by a very thin majority of 6-5, did say that these are inalienable rights. For example, the very first right that comes to our mind is liberty, and has been so beautifully ingrained in Article 21 of the Constitution of India. Even the entire Constitution and the chapter on fundamental rights, it is this precious right which is preserved. I am emphasizing the word preserved because I began by saying that this idea of preserving, rather self-preserving of a human being, that is squarely ingrained in Article 21. It is this fulcrum which has been described by many eminent jurists. I am just borrowing it from them. That Article 21 is one of those articles in the Constitution that reflects upon this instinct of the natural right of man to preserve himself. Such a right, I do not think anyone would like to give up, and what the people do not want to give up cannot be altered by any law, by any legislation, nor can it be taken away by any parliament or any might of the government. It is this tyranny which I was referring to right in the beginning that people want to defend themselves from. And therefore, the Supreme Court and our eminent jurists have very rightly come forward to support this basic structure doctrine, which has preserved not only the individual but the nation as a whole. Yet then a doubt comes to your mind. Any structure or any document, even books get revised, theories get revised, scientific theories are being upturned, technology is having a fast advance. Any structural theory needs space to expand and to remove what I would describe the suffocation of law. This broadly encompasses two things. One is the development of law, and the other is the protection under the law. So in order to avoid this suffocation, how do we say and how do we justify the existence of these basic doctrines? I have hinted at the doctrine of separation of powers, and avoidance of rule of tyranny on the one hand. And now I enter the second most important feature of the basic structure doctrine, which is the power of judicial review. If we begin with this premise, applying any theory of law, that the sovereignty rests in the people and the people can change the constitution. And if we develop this further, as I said earlier, that no person would like to change it when it comes to these basic elements like liberty. And if the people are put in a quandary where, in spite of wanting a change or wanting an interpretation that reflects an injunction against change, how do people get this right to do it? There are two ways. One is at the hustings, that they express themselves through those political parties which govern us and form the government, and they declare it in their election manifesto and then implement it in parliament. But the experience has been otherwise. After being elected into parliament, what happened is history. Constitution was altered and came to be described as a black day in history when it was changed to suit a particular individual. The same story I would remind you to connect it with Weimar Republic and German Constitution, which later came to incorporate the Tyranny clause. It is the power of judicial review. Where the parliament fails, judiciary steps in. Why? Because not only of the faith that the people have in this institution, but because the constitution has been ordained in a manner allowing the judiciary to reaffirm this faith. And time and again we have seen that the judiciary has stood up to the cause of the people and it has defined what basic structure is. And therefore this power of judicial review is one of the second most important pillars of the basic structure doctrine, where even a single individual, be it a saint like Keshavanand Bharti, or even one of the most haunted criminals of the country, can very safely rely on and come to the courts, constitutional courts, for the protection of such rights that are ingrained in the Constitution. This is that basic instinct of self-preservation, which our courts pronounce through their judgments. They help to preserve what belongs to the individual. They help to preserve what is sought to be preserved in the name of humanity. It is sought to be preserved in order to contain this vast civilization, which we call a nation, a country, and a whole of unity and integrity. The judiciary, therefore, plays this vital role, and therefore, I consider this to be a very vital part of this basic structure doctrine. There are other basic features, as I stated earlier, the fundamental rights, the directive principles of state policy, theories of nationhood, all these things are there. But again, I would like to put this question to you. How do we educate our future generations to keep an eye and to suggest either a change or an injunction. Now it is here that the role of our educational system in the country, whether it is at the grassroots level or at the university level, plays a very dominant role. We have many institutions with different styles of functioning, and they profess different theories and go to the extreme of bringing about and advocating change. The responsibility lies on the shoulders of those who think that a change is required. And I use the word responsibility because whenever a change is required, we should not forget that our constitution framers had not only toiled day and night for years together, but our freedom fighters had fought before that to define such basic features which form part of our constitution. We should not forget the path that was trammeled by them. The reason is, and again coming back to the theory of natural law, which requires ethics and morals also as the foundation, to be one of those principles which have to be kept in mind when we advocate the cause of a change. There may be archaic provisions or such provisions which require an immediate change and in the long run a change for the better. But the doctrine of separation of powers and the power of judicial review should be very sparingly touched upon. The reason is, will of the people should not be compromised when it comes to these cherished principles, whether it is contained in the fundamental rights chapter or whether it is contained in any form, in any law made by our parliament and legislatures. They can be molded according to contemporary needs, fluctuating with the need of the society and the demand of the public. But the basic instinct is to avoid any form of excessive governance that may tend towards tyranny. This also includes framing of even petty laws that affect life of an individual. But they may be petty, yet they hit the basic structure. And if they hit the basic structure, then, as I stated earlier, people can go to the hustings to alter it, or they have a mighty remedy available as a judicial review power, which will, I think, survive for generations to come. It will be a sad day for our constitution if we try to abrogate it or upturn it in a way so as to strike at the root of these cherished ideals. Even though, as I said earlier, any structure does require expansion and any form of suffocation does require a window opening. As again repeating it, nothing is permanent but change. But nonetheless, as the German constitution says, there are certain eternal causes. And in my opinion, if we want to survive as a united and a strong nation, preserve the wishes of the people, then this system of constitutional supremacy, the system of a federalism, rather that of cooperative federalism, as Granville Austin put it, has to be preserved and should be understood as those basic principles and features that form the basic structure of the Constitution. I thank all of you for giving me this opportunity to speak on this, because this question keeps on troubling me. Why not change something for the better? But when it comes to change, it is always better to remember Mahabharata, which I often quote, that you should always tread the path that has been tread by your peers, Mahajano, Katena Sapata. I would therefore believe in my own people who would empower best of parliamentarians, preserve this basic structure, and may give all entire legal fraternity the strength to live up to this ideal, which I wish would remain preserved, which is the basic instinct of every individual and every collective organization. Thank you very much.
Thank you very much, Your Lordship, for a very, very thought-provoking and a very relevant speech. To begin with the questions, Malad, if Your Lordship is ready, I will have somebody to start with this.
Yes, I am ready.
We have Mr. Avinash Krishnan Ravi, Lord, with his first question. Avinash, you can unmute and ask the question.
My lords, good evening, my lords. My question, my lords, is regarding the relevance of the basic structure doctrine to original legislation. Because initially, I think the Supreme Court had said it would not apply, but subsequently, I think they deferred. My lords' views on that would be really helpful, my lords. Thank you, my lords.
You see, that principle has already been enunciated, not once but several times, right from Keshwanand Bharati onwards. You see, this is where the conflict of the constituent power of the parliament came to be discussed. The constituent power is supreme, but they laid the caveat very firmly that this constituent power to change the original form of constitution cannot be exercised when it comes to the basic structure doctrine. That theory, as enunciated by the Supreme Court, still holds good, and I believe in it. The reason, I may tell you very frankly, had the chapter of fundamental rights or the enunciation of our courts not been there, there would have been many catastrophes in this country, and they had already begun, because the faith of the people, you just see the ordinary and common man. A villager fights with his neighbor in the village, and do you know with what he threatens him if he is in a civilian mood and not in a criminal? He says, if you do this, I will make you fight up to the High Court. Why does he say this? It is this faith in the entire judicial system, and therefore to allow the parliament to tinker with this original faith which the people have in the constitution would not be permissible and should never be permitted. So therefore, I am quite clear on it. Any form of legislation which hits and is capable of being criticized on the anvil of the basic structure doctrine has no place to stay, and it has to be struck down.
Thank you, my lords. I have Arvind Srivatsa with his question. Arvind, please get it.
Yes.
My lord, thank you for the very informative lecture, my lord. Lords, my question is on tribunalization. My lordships were pleased to refer to the case of Marbury versus Madison while speaking. Lords, in India, broadly speaking, judicial review has three main aspects. One being judicial review of legislative action, one being judicial review of judicial decisions, and review of administrative action. In my lordship's understanding, is Article 368 in somewhat broader in perspective than the objects and reasons of bringing into force of Articles 323A and 323B, my lords, which was brought in by the Fourth Amendment.
Definitely. And you will find this reflection clearly. You should be proud about the Madras High Court because L. Chand Kumar belongs to Madras. The two Madras Bar Association cases arose from here, National Company Law Tribunal, and then again the second case, the Tax Tribunal case. So therefore, there is definitely, that is why I refer to, and if you have the Constitution with you, you just read Article 368. It begins with non-obstante clause, notwithstanding anything contained in the Constitution. Notwithstanding contained. And any amendment. Now, this has a very wide sweep. And therefore, you see, just remember, the earlier cases of Sajjan Singh and Golaknath, they had all referred to Article 13, law made and whether the constitutional purpose. So they came to be explained in Keshavanand Bharati, and which has been followed from time and again. That is why you must have seen that in all these cases, the judicial element was emphasized, whether it was the tribunal, tax tribunal, whether the National Company Law Tribunal, whether it was their qualifications. The independence part and the judicial part was emphasized. The tribunalization should not exceed the constitutional supremacy. Constitutional supremacy is still there, and 226 and 227 for the High Courts and Article 32 for the Supreme Court. Of course, Supreme Court also has Article 142. We will not enter into that question for the time being, but nonetheless, this is what has happened, and that is why you see, this cannot be tinkered with. Once you allow the highest courts of the state or the highest court of the nation specifying reduction in their powers, I think that will be hitting at the root of what I would say is judicial federalism. The whole judiciary is a separate governance provided for in the Constitution, where the hierarchy is the Supreme Court in appeal against the judgments of the High Court, and of course with its other powers under Article 142 of the Constitution of India. Coupled with Article 32, where it can go to examine any of the fundamental rights violations. But at the same time, you must have come across those cases and you must have gone through it. I will not repeat them. At Article 226, what does it talk of? It talks of a variety which you lawyers call the limit whereof is the sky. This is a phrase used in order to understand the power preserved, and which is what? The faith preserved of the people in the judiciary. Please take it to that level. And therefore, any form of criminalization or any form of introduction does not in any way tinker with those basic structures, basic features which form the basic structure of the Constitution. This has been very clearly explained, and wherever it has done, that part has been struck down by the Supreme Court. We have seen it in all those cases. There is no need to expand further on that. But nonetheless, 368 has a different color altogether. It is still preserved, and 368 has not yet been amended. Again, for that matter, it is still preserved in order to see that it does not travel beyond what the Constitution. After all, 368, if we believe in constitutional supremacy, then 368 is also part and under the Constitution.
I'm greatly obliged.
We have Mr. V. Lakshmi Narayanan Malod with his next question. Mr. Lakshmi Narayanan, please unmute yourself and ask.
It's, good evening, Milords. Thank you for the illuminating lecture. Lord, may I venture to make a few observations before I ask the question?
Yes.
Now, you had spoken about referendum. Now, most of the countries which have a referendum, for example, Sri Lanka or Australia, or for that matter, Ireland, one, they are not kind of as diverse as this country. And what the problem is, we call it referendum or a plebiscite. Hitler and Mussolini both used this option in order to abrogate the existing constitution.
Yes, exactly.
One. Second, insofar as an election manifesto, if, for example, any party was to say that we will bring an amendment which will be against an election, which will do away with the basic structure, and if they don't do it, courts have said the election manifesto is not enforceable.
That's right.
Up till the. So, isn't it? I mean, one further thing is, would you say that the solution lies in the courts itself, where they have said separation of powers is a part of the basic structure, and if the parliament is given the power to amend it, that falls within exclusive its jurisdiction, and court should stay away and therefore restore the basic structure by overruling themselves? Or should we say Keshavananda by holding that the inherent and limitation powers is recognizable only by the courts, they have affected this very basic structure of the constitution and they have violated the constitution itself.
You see, that is why I emphasized on this, that there are two very important basic features which are part of the basic structure of the constitution. One is the separation of powers and the other is judicial. Very plainly, I will repeat again, people go to the hustings, election manifestos not lived up to, or lived up to but violated. Vis-a-vis your original question relating it to Mussolini and Hitler. Yes. That is why I believe, and this is the belief of other jurists as well, my belief is just borrowing that belief. It is not that I am giving an original thought or something of that, but I reaffirm it in the sense that judiciary is the last bastion which any powerful government would like to tinker with.
Okay.
So therefore, judiciary has to remain strong, and this power has to be acknowledged in judiciary, that it has the strength and it has the capacity to strike down a law made by parliament, howsoever powerful the parliament might be, if it hits the basic structure of doctrine. Because it is this which will infuse the faith in the common man, that look here, my constitution is there and one form of government will protect me if the other overreaches over it. That is why this unique position is there. And unless you believe in this, I tell you, I'll just remind you of one small speech. I have referred to it earlier also. One of the former Advocate Generals of the state of Uttar Pradesh, Pandit Kanhaiyalal Mishra, he was extempore called upon to speak before our late President, Dr. Radhakrishnan, on the occasion of the centenary celebrations of the Allahabad High Court. And the speech that he made is history. And there he says, this institution is for justice, that sense of justice which every human being aspires for. Now, if that is the level of expectation from the judicial system, then there is no need to dilute the relevance of the judiciary. Because once we do it, we tinker with the faith of the people. This is how I see it. The faith of the people has to be preserved and preserved by advocating this preservation of extremely cautious power which has been given by the Constitution. And if the constitutional supremacy has to be maintained, unless it is altered, and God may help us that it is no longer altered in future, I think we should stand by this very theory. Yes.
Thank you, Lord. Thank you, Lordship. We have one last question from Mr. Naveen. With that, my Lord, the questions. Naveen.
Good evening, Lordship. Lordship, the general principle that law should be dynamic and not static. So the concept of the doctrine of basic structure was brought in by Supreme Court 50 years back, almost 5 decades. Much time has passed by. There are a lot of developments and changes in the society and also in the lives of people. So should lawsuit feels that is a doctrine also should be dynamic and molded from time to time in order to suit by the current trend in society, or how should be very static so as to go with the original concept of doctrine of basic structure?
Yes. See, view it from this point of view, nothing is absolute in this world. Nothing. This is the basic theory that you have to understand. What of it? That tomorrow there is some sort of a public revolution throughout the country. And it says that we don't want democracy. We want some form of other government here. So if the sovereignty vests in the people, and if the people ultimately come to this, that no, we want a change, can we say that this constitution is not susceptible to change? Everything is susceptible to change. And this is where there is no need to go about dynamism. The dynamic rule has been explained as that the constitution is a living organ. And you have seen this with 120 amendments, with introduction of so many chapters, with so many pronouncements from the judicial side. The constitution itself may not have defined these things, but they have come to be defined through judicial review, to even introductions and amendments. And therefore, I don't think that the constitution is static. It is developing, maybe in a different form with the introduction of certain elements which may be debatable, that it is more federal in nature or more unitary in nature. That is a different issue altogether. But it is changing. And you cannot, who can prevent change? And even otherwise, I will just make a statement of a fact of life. Unless you change, you don't have refreshment. It is only a dead body that floats and gets carried at the bank. Person who is alive, he will swim across the river. So dynamism as a concept is inbuilt in the constitution itself, and that is why this power of amendment has been constitution. We don't think so that if the people wish, they can bring about a change within the scheme itself. And as I said, the most important instrument, power of judicial review, that can always be invoked to pronounce upon it. And if I may say so, now the Supreme Court's proactive roles through the decisions that it has rendered in the past decade, you can well imagine that this in itself is the legal dynamism of the constitution itself, which is being explained by the Supreme Court. Yes.
Thank you, Lord.
Lordship, there is actually one more question. If the Lordship is willing, my Lord, I'll have the question asked.
Yes, I'm free at home.
Obliged, Lord. We have Vishnu Ramu, another young Turk from the Madras bar. Vishnu, please go ahead with your question.
Good evening, my lords. Just a continuation of the earlier question. I just want to know, I always feel that the basic structure doctrine is an essential veto power exercised by the court over the constitutional amendment. So, is it not high time that the Supreme Court defined the content and scope of the doctrine in an unambiguous manner?
though it is very difficult to define it. Court, actually, when it comes to these definitions, what we are trying to define is life itself, whether it is Article 21, whether it is Article 14, whether it is administrative action, whether it is judicial review, whatever it is all correlated to life, the life of a human being and the life of a nation as a whole, the society, whatever adjective you may give it to. But I must tell you that to give an exact definition is not possible because each situation is different from the other. So to define one situation in a particular context may require a different reason for reaching at that conclusion, whereas on a different set of facts, you will require a different set of reasoning to arrive at the conclusion to protect what is given under the Constitution. Maybe it is related to the same article, maybe it is related to the same fundamental right, but these different facts bring about different shades of protection, which you must have experienced as a lawyer, whether it is arbitrariness or whether it is discrimination, whether it is hostile discrimination, whether it is reverse discrimination, all are related to Article 14. But there are different shades which arrive at the same conclusion that look here, because of this, the act is right or wrong. So therefore, a precise definition through a judicial pronouncement may not be possible, even though the same line of problems may get the same treatment. That is something different. Yes.
Thank you very much, Malats. In fact, in this WebEx meeting, we had the pleasure of the company of Justice Suresh Kumar and Justice Satish Kumar also. We have Justice Suresh Kumar here. If you would like to say a few words, he could. Justice Suresh Kumar, would you?
Yes, please. Welcome.
All right, I think he is not unmuting himself. So I will request Justice Mr. Parthasarathi, senior advocate. Yes, he's here. Justice Suresh Kumar. Justice Suresh Kumar, you can say it. Suresh Kumar.
Hello?
We can hear you.
Yes.
Please go ahead.
I'm able to hear. Chief, good evening.
Good evening, brother.
Chief, good evening.
Good evening.
How are you, Chief? At least we are able to see the face of our Chief through webinar.
My face is available every day in the High Court. If anybody wants to see it, it can see it.
Yes, I was told that registry people that Chief is visiting that High Court and doing all this administrative and other work. Anyhow, sorry Chief, I joined only belatedly in this webinar. Last couple of minutes only I was watching. The full program, that video program, if it is available, that I think the organizers can send it.
Yes. They can even ask them.
It is uploaded in YouTube.
Yes, Chief.
Or it can. Thank you, Justice Suresh. Thank you very much for joining.
Certainly. Yes. Thank you, sir.
Thank you. May I now request Mr. S. Parthasarathi, the senior advocate, the chairman of MBA Academy, to say a few words as vote of thanks.
Yes.
Am I on?
Yes, please.
Parthasarathi, sir, we can hear you.
Am I audible?
Yes.
Yes, sir, you're audible. You can start. Good evening. Let me begin by thanking Honorable Chief Justice A.P. Sahi, for having taken the time out
to address us.
Camera, so your camera has to be adjusted.
I'll just go ahead without
It's all right. Now it's right.
Good evening. Let me begin by thanking His Lordship, the Honorable Chief Justice, for taking his time out to address our members today. We are deeply grateful to Your Lordship. We are deeply grateful to Your Lordship. To many of us who do not practice regularly in the field of constitutional law, some of these concepts can sound daunting. But Your Lordship explained the concepts in such a simple and easy manner, yet without compromising on the essential and technical aspects of the doctrine of basic structure. It is a very, as the Lordship pointed out, it's a very great responsibility rests with the judiciary to preserve the Constitution, and we have also gathered why it is very clear, even from the text of the Constitution, there are certain limits to the amending power vested in the Parliament. In so many ways, I should say, my Lord, that this lecture was eye-opening and inspiring. On behalf of, therefore, Madras Bar Association and the Academy, I once again thank Your Lordship for speaking to all of us today. Thank you, my Lord.
Thank you.
Thank you very much, my Lord, for the time and the lecture. Thank you.
Thank you. Thank you.
Thank you, Lord.